My name is Emily Thrush, and I'm the project coordinator at Equitass, the Prosecutors Resource on Violence Against Women, and I'll be moderating today's webinar. It's about context, not character, admitting evidence under the Rule 404B is our contribution, one of our contributions to Domestic Violence Awareness Month, which happened this month, October. Proving a crime of intimate partner violence challenges prosecutors to place the criminal act in a context of the bigger picture of the relationship and its dynamic of ongoing power and control with various forms of abuse that may span years or decades. And it's important to present the fullest possible picture of this relationship to enable the jury to understand the defendant's motive and intent to inflict harm. And this can be done through the admission of other crimes, wrongs, or acts under Federal Rule of Evidence 404B and the equivalent state or tribal evidence rules of statutes. So today's webinar will identify types of evidence that may be admissible for purposes permitted under the rule. It'll suggest ways in which admissibility under the rule can be argued, and we'll discuss important considerations to avoid reversible error on appeal. Today's webinar is hosted by Equitass, the Prosecutors Resource on Violence Against Women, through the funding from the U.S. Department of Justice, Office of Violence Against Women. As Patricia noted, we do have the slides for the PowerPoint presentation that you'll be seeing, and there will be a biography that we'll send out of the presenter, my colleague Jonathan Curlin, after the webinar. Equitass's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Our Equitass staff conduct legal research, provide 24/7 case consultation, we host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and we publish resources on topics relevant to the prosecution of violence against women. The individualized assistance Equitass provides is data-driven and incorporates customized strategies that are easy to implement, resulting in prosecutors' ability to sustain effective practices and promote systemic change. Today's presenter is John Curlin, an attorney advisor here at Equitass. With Equitass, John provides training, case consultation, and resources for prosecutors and allied professionals handling cases involving violence against women. Prior to joining Equitass, John worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, where he served as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, he has successfully prosecuted domestic violence homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. Jonathan is based in Berks County, Pennsylvania, and as I said before, I will provide a more complete biography after we finish this webinar. So now I'd like to turn the floor over to John for the substantive portion of today's webinar.
Thank you for that introduction, Emily, and thank you, Patricia, for facilitating this webinar today. And thank you for everyone who's participating on this last day of Domestic Violence Awareness Month on this important topic about how to get in a defendant's other bad acts, sometimes we just say prior bad acts, under Rule of Evidence 404B or the local jurisdictional equivalent. What our objectives are going to be for today's proceedings is, as you can see from the slide, we want to work to try and identify evidence of other acts or evidence that can be admissible for a proper legal purpose under Rule of Evidence 404B. We want to talk about best practices and methods we could use to successfully argue how to admit such evidence. And last, but certainly by no means least, we want to talk about ways we can protect the record on appeal by proposing proper limiting instructions for the jury so that when we get a conviction, by properly and ethically utilizing this evidence, we can protect that conviction on any sort of subsequent post-trial appeal. Now, before we get into a little bit of the specifics of the rule, I want to talk about usually when we're working on domestic violence cases or sexual violence cases and human trafficking cases, we usually only encounter and sometimes manage these cases from what is readily observable in initial response. I'm speaking, of course, about when police respond to a report of domestic violence, when the sexual violence victim comes in and discloses the abuse. the focus, the investigative focus, and often sometimes the prosecutorial focus, is just what happened on that, with that one incident or in that one occasion, that one day or that one period of hours. The challenge in managing cases, prosecuting and investigating cases in this manner, it's like trying to figure out how to get somewhere by only using a street view of the destination. That can sometimes be doable, but it's harder without some kind of overall view showing the route or the directions or just the area in which you're trying to get to and from. Well, when we want to get directions using a map from somewhere, we can zoom out and we can try to get context on how to get somewhere. We want to try and figure out how to do the same thing in response to intimate partner violence and sexual violence. And that is, we want to try and be able to show the jury, our fact finder in these cases, what is the whole picture, the whole story, and the context in which the crime occurred that initiated this original police response. What brought our victim through the door? Now, why is it important to provide context? Well, if we only offer our fact finder, our jury, and to some degree our adversaries on the defense, a snapshot or a street view of the incident, it can become very easy for victim behavior to be misunderstood and harder to bring offender accountability. The complete story being given to the jury helps them to make a more reasoned decision based on the evidence and not a decision based on myths or insufficient information. Our victims who are in a relationship with the offenders, who have relationships with these sexual violence perpetrators and domestic violence perpetrators, our victims live lives with these people. And as investigators and prosecutors, if we're trying to show what happened during one day, it's very difficult method to provide a complete picture. We want to try to find proper legal and ethical methods so we can give a jury the whole picture and prevent the victim's behavior from being misrepresented or misunderstood, as well as to make sure the offender doesn't escape accountability for their actions through an incomplete view of what happened in the context of the crime. Now, there's several legal vehicles we can use to provide evidence of context to the jury. And the primary one we'll be discussing in this webinar is going to be how to offer evidence under Rule 404B, Rule of Evidence 404B. But I want to discuss some other options as well, or at least just briefly address them if I can. Other methods which we can use to show context of an offender's behavior and of a crime which we're prosecuting is by making strategic charging decisions. And this is something that might be perhaps underutilized by investigators and prosecutors. A lot of times if we use proper crimes when we're investigating and prosecuting course of conduct incidents, it's a better way to show a jury a whole picture. Folks and prosecutors and investigators who work in narcotics, trafficking, and or organized crimes and gang prosecution are familiar with using racketeering statutes as a way to open the relevancy window of admissible evidence and help to show context to a fact finder. When we're prosecuting intimate partner violence and non-stranger sexual violence, a properly investigating stalking charge can help do some of the same things that narcotics people and gang people and organized crime people use racketeering statutes for. Almost every jurisdiction in the United States has a stalking charge which allows us to charge a course of conduct of an offender's actions towards the victims. By doing a full investigation, oftentimes we can try to get in an offender's prior bad acts by including this charge, and the defender's prior bad acts then become an element of the prosecution, of the charges, of the crimes charged in the prosecution. In addition, as we're doing a fulsome investigation, some prior bad acts may actually be crimes that weren't originally prosecuted and which jeopardy has not attached. When we find such indicators, we should explore statute of limitations issues and see if they can be charged along with the current, whatever charges are in the current case. Other methods, legal methods we can use to provide context to the jury of an offender's conduct and criminal activity is through re gesti and consciousness of guilt. These are vehicles that can open the relevance door to help prosecutors show the full context of criminality surrounding a defendant's conduct. However, due to time limitations, it's not something that will be fully developed in this webinar. The primary avenue from which we'll be discussing about how to get bad acts admissible is through Rule of Evidence 404B. That'll be our main focus on means of showing the jury context in an intimate partner violence case or in a sexual violence case. And I want to pause here and give a little note on terminology. Evidence which can be admitted through 404B, evidence of the offender's conduct, it doesn't necessarily have to be activity or conduct that's prior to the criminal activity that's being charged. However, often, and because this was the way I was brought up using evidence 404B, we sometimes talk about it as prior bad acts. It's more properly considered as just an admissibility window to bad acts generally. These can be bad acts of an offender that occur after the crime was committed, activities such as witness intimidation and things of that nature. However, if during this webinar I generally reference prior bad acts, that's a mistake on my part, and I mean to more generally say bad acts. Rule of Evidence 404 is the most common vehicle used to introduce evidence of bad acts. However, we're speaking to a national audience, so recognition needs to be given that the rules in any individual jurisdiction can vary. Be familiar with the parameter of bad act 404 evidence in your own jurisdiction, and of course Equitass can be available for technical assistance with research that is jurisdiction specific if you want to explore or just have us assist in exploring the scope of admissibility under your local version of 404B. However, for purposes of this discussion as a generic placeholder, we're going to be referencing the federal rules, but we're going to try to identify areas where jurisdictions can differ on issues of admissibility relating to 404B evidence. Now, we talk about Rule of Evidence 404B, which is the rule of inclusion. But we should give some reference and note to the first paragraph in that rule, which is Rule of Evidence 404A. The general rule of exclusion of character, and what 404A is, it's the general rule of exclusion in that character evidence cannot be introduced to show a propensity for a defendant to have committed a crime. That's what's talked about in 404A1. And this, of course, is consistent with the principle that we prosecute people for what they did, not for who they are. And that fundamental principle that we don't try to convict someone with evidence just that they're a bad person rather than what they did is also why defendant misconduct evidence or defendant bad act evidence can be one of the most frequently litigated issues on appeal and one of the most common grounds for reversal. This tension between prior bad act evidence or bad act evidence being admitted for a proper purpose to show something as opposed to an improper purpose where it's just used to show the character is what makes this area so ripe for litigation. Well, if 404A is a rule of exclusion concerning a defendant's other conduct, then 404B is a rule of inclusion. 404B2 specifically is the door through which a defendant's prior bad acts might be admissible if evidence of that prior bad act is offered for a proper purpose. And what is or what is not a proper purpose is the crux of what litigation is made of. And proper purposes, which we're going to try to delve into more deeply in this webinar, a proper purpose can be to show motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accidents. Now, the articulated purposes in the rule, in almost every jurisdiction and every circumstance, it's not exhaustive. There can be other reasons other than the ones specifically enumerated in 404B2. The scope of evidence that can be admitted under 404B, it's also what I would suggest, it's not as intuitive as what's excluded under 404A. We have to lay the foundation. We have to educate our courts. We have to educate our fact finders. We have to educate our defense bar to some degree as to the scope of which we are seeking to admit evidence is not for an exclusionary purpose to show the defendant's bad character, but for an inclusionary and proper purpose under 404B. Now, the scope and grounds of admissibility can vary with jurisdictions. Please note that if we look at Federal Rule of Evidence 404 as a model rule, it includes a notice requirement. Most local rules do, but not all local rules. So we've broadly outlined, hopefully at this point, the what kind of evidence is admissible as prior bad acts or bad acts. We now want to turn to the how by referencing or by making reference to different procedural points when a criminal case is litigated and what we can do during that process to try and lay a proper foundation and proper method for evidence under 404B to be admitted. As an overall point, it's fair to say that transparency should be the overall watchword in attempting to introduce evidence of a defendant's bad acts, prior bad acts or subsequent bad acts to the crime. Regardless of whether the local rule in your jurisdiction is silent on the specifics of procedure, prior bad acts evidence is not the type of thing that should be sprung as a surprise during trial. Using a surprise practice for bad act evidence increases the risk of mistrial, and in the unlikely event it's even admitted, the record could be compromised in the appeal of any conviction. So regardless of, usually most local rules are going to require some kind of notice. Even if our local rule or your local rule doesn't require notice, we want to be sure to give notice to the defense of our intentions to offer bad act evidence. And we want to try and be as specific as to the nature of the evidence we want to permit and the purpose for which we are seeking to admit it. By making efforts to give notice of our intent to use evidence under 404B and make discovery available to the defense so they know what kind of evidence we're offering, the record is thereby protected, and we can also blunt the defense arguments of surprise and unfair prejudice. Once a bad act evidence is identified that we want to try to utilize during our prosecution, we should file a pretrial motion in limine asserting all potentially applicable grounds for admission. Often, bad act evidence can have overlapping purposes. The purposes that I've already referenced in the prior slide for which bad act evidence can be admissible, it shouldn't necessarily be considered mutually exclusive. Oftentimes, bad act evidence we're trying to seek to introduce can be admissible, and we can argue its admissibility for overlapping purposes. By preparing a written pretrial motion to the trial court, arguing the legitimacy of the admissibility of such evidence, it helps us as a prosecution to think about and refine the issue. It also educates and informs the trial court about the scope of why we want such evidence admissible. Most importantly, not most importantly, but also importantly, by making a written pretrial motion as detailed and as specific as possible as to the nature of the evidence we're seeking to introduce and the reason we're trying to seek it, it increases the scope of a record for an appellate court to consider. So if the evidence is ultimately admitted by the trial court, and that's an issue that our defense appeals after hopefully a conviction happens, the written motion we utilize is going to be something helpful for the appellate court to reference as to the purposes which was admitted. This can be especially important if perhaps you have a trial court that doesn't put detailed reasons on the record as to why they are admitting such evidence. In other words, there's a wider basis for an appellate court to judge the trial court's use of discretion or exercise of discretion in allowing the prosecution to admit 404B type evidence. The other thing to note is that standards of proof for the admissibility of 404B evidence can vary by jurisdiction. The Supreme Court has applied a preponderance of evidence standard for any evidence offered under Rule 404. Some jurisdictions in the United States apply a clear and convincing standard. Other jurisdictions just apply a basic competency standard like any other kind of evidence in trial and let the jury then decide the credibility and weight of any 404B evidence which we are permitted to introduce as a prosecution. The other important point to protect the record on appeal when we are allowed and permitted by the trial court to utilize prior bad act evidence is we should always encourage our trial courts and even propose to the trial courts proper cautionary instructions to the jury, limiting instructions. Again, transparency is usually the best watchword to try and protect the record of cases in which we are using prior bad act evidence. And a cautionary instruction in the nature that the jury specifically instructed that this evidence is being offered only for the purpose of showing motive or intent and is not meant to impugn the defendant's character and shouldn't be considered for that purpose. Often that simple record can protect that simple instruction can protect the record on appeal. Sometimes the defense may not agree to that sort of instruction because they don't want to draw more attention to the evidence which we're seeking to introduce, but usually then that waiver of the instruction further protects the record on appeal. Now, the Supreme Court established or recognized the admissibility of prior bad evidence or the admissibility analysis to be utilized for the federal rule of evidence 404 in the case of Huddleston versus U.S. This was a 1988 case, and this was a federal prosecution of a federal crime brought in the Eastern District of Michigan. Now, in the scope of application of Huddleston, it wasn't a decision of constitutional dimension. The Supreme Court was simply analyzing the scope of the federal rule of evidence, specifically Federal Rule of Evidence 404. They weren't making a constitutional determination. For those among the participants who are court watchers, what Huddleston versus U.S. involved, it wasn't any sort of intimate partner violence or human trafficking case. It was actually a receiving stolen property type nature. Huddleston was selling stolen video cassettes, and it was a tremendously marked down price. And the government in that case wanted to introduce evidence of when Huddleston had sold such items at the full price rather than the marked down price to show his knowledge or as evidence of his knowledge that the video cassettes were stolen and that he should have known they were stolen. But the reason why we talk about Huddleston versus U.S., even if it's only referencing and discussing an admissibility analysis under a federal rule, is that the admissibility analysis utilized by the Supreme Court in Huddleston, it's typical of what is in most jurisdictions. And there are several prongs to the admissibility analysis. And one of the first prongs for any admissibility of bad act evidence under Rule 404B is that the evidence has to be admitted for a proper purpose and not to demonstrate the offender's propensity to either commit the crime they're charged with or just that they're the bad apple or bad egg. Now, proper purpose is what we've already referenced and is specified in the text of Rule 404B. And proper purpose, of course, incorporates motive, opportunity, intent, prior preparation, knowledge, identity, lack of accident, and mistake. The other prong is that the evidence must be relevant to the charged crime, and I'd suggest that that's usually not a very hard prong to argue or to meet. Probably one of the most contested of the prongs of admissibility of 404B evidence is the third prong, is that the proffered evidence, probative value, what it proves, cannot be substantially outweighed by the danger of unfair prejudice. Now, of course, double check application in your own jurisdiction. However, in arguing the probative unfair prejudice balancing, it's important to help the court understand that the probative value is increased in the context of the difficulty of your case. And what I mean by that is the more challenging your case is, the less evidence you have, the more of an environment of secrecy in which our defendants committed their crime, then the greater the probative value is of this bad act evidence we're seeking to introduce under Rule 404B. Now, arguing essentially to the court or to your trial court, judge, my case is really tough. That's why I need this prior bad act evidence or this 404B evidence so badly. That can be delicate because you don't want the defense necessarily to develop strategies they might not have been previously considering. However, we should also argue and emphasize when we're talking about the probative prejudice, unfair prejudice balancing, is that any trial is inherently challenging for the prosecution, as we always have the burden of proof. It's the highest burden of proof that exists under the law. And naturally, it can be compounded by the inherent challenges that we face in intimate partner violence and sexual violence cases. Now, often in the defense in objecting to this kind of evidence, they complain about the prejudicial value of the 404B evidence. And I'd suggest that probably the easiest response to that, specific to what's happening in your individual case, is that all evidence we utilize is prejudicial. That's the purpose of evidence which we're seeking to introduce, is to show the defendant committed a crime that they're guilty. But what we're trying to show with the evidence we're seeking to introduce under Rule 404B is that that evidence isn't unfairly prejudicial. And we want to tie the defendant's conduct in as to what makes this 404B evidence so necessary. Judge what happened when the defendant committed this crime. The defendant committed this crime. There weren't any other witnesses around. He took advantage of a victim that was vulnerable. So for us to be able to prove our allegations against him, which is why we need these prior bad acts to show that. Put it in the context of how the defendant's actions and the evidence in the case makes this 404B evidence so necessary for our prosecution. And to blunt any arguments or danger of unfair prejudice, we should stress to the court and propose to the court that the court give a limiting instruction as to the purpose, the limited purpose in which we're trying to seek to introduce 404B evidence. I do want to note, when we're utilizing or seeking to use bad act evidence that may have involved a prior acquittal, in the federal courts, they've allowed admission of prior bad acts for which the defendant may have been acquitted. And this is when the prior bad act involved, of course, a prior crime. Some states have specific rules disallowing this. Some states, I think New Jersey is one of them, that did not allow bad act evidence that was the basis of a prior acquittal. Some states do allow evidence of a prior acquittal to come in under Rule 404B, but require that evidence of the acquittal also be admitted. However, in presenting bad act evidence, whether the bad act evidence is a prior conviction or a prior acquittal, what we want to do in trying to procedurally get the evidence in front of our jury and the fact finder, we want to focus on the witnesses that prove the conduct, not the result of a prior judicial proceeding. So if we have prior victims, prior sexual violence victims that are willing to testify in a case, in our current case, the victims can talk about what the defendant did in their case, which can help show whatever the proper purpose is in the present case. The fact that he was convicted or not convicted really isn't as helpful to the fact finder as to the specifics of what he did in that bad act. Will help them make their determination, and when we're trying to show motive, intent, or what have you. Now, where can we find, or where do we look for evidence of other crimes, wrongs, or acts? Well, the short answer can be from anywhere in the defendant's life. The long answer is that a defendant's bad act evidence may not be packaged neatly and conveniently for us. A lot of times when bad act evidence is found, it's going to be the product of cooperation with law enforcement and advocates and following trails of breadcrumbs. Probably one of the initial sources we should look at for prior bad acts evidence, especially in intimate partner violence and in non-stranger sexual violence cases, is we want to talk to the victim. And we want to talk to the victim and allow the victim to talk to us about what happened, not just on the time when police responded, but we want to try to almost take an entire social history from the victim, and we want to do this in a victim-centered and trauma-informed way. When we're trying to learn from the victim, we should recognize that memory and ability to recall sequence of events can be impacted or impaired if there's immediate trauma. We want to ask questions that are designed to elicit specific memories and facts, and we want to ask questions about various forms of power and control. When we're meeting with our victim and when we're talking to our victim and when we're investigating the case with our victim, we want to try and get a full account of the relationship and his or her knowledge of history with the offender, not just when the crime occurred, but since the beginning of that relationship. And maybe the best way, and some of the best ways we can do it, is a few days after the initial crime has occurred, and the trauma may not be as acute or as intense. We sit the victim down, or we meet with the victim in an environment they're comfortable with, and we just talk to them. And we ask them to talk about the history of the relationship, and we start learning about the entire evolution. And if we just have that conversation, and our investigators have that conversation with the victim, we can learn a lot more, and we can find evidence of prior bad acts in that. Some of the prior bad acts we might learn from a victim, or that we can learn independently by talking to law enforcement or looking through criminal history, might be actual prior police response or law enforcement responses. We can learn about these prior bad acts by getting those cases, asking the victims, especially when we look through a criminal history and we see charges were dismissed, or there maybe was a resolution to a lesser charge. We can talk to our victim about, well, what happened back in that case? Why didn't you participate? Why didn't it go forward? Why was it this charge? And we can find a little bit about the background that perhaps our victim wasn't originally able to talk about or participate with us back when that prosecution happened. And we can bring that into the current case to try and show the defendant's motive or intent in his current crime, which he's being prosecuted for. If we have cold case sexual assaults, not necessarily just cold case sexual assaults, but for sexual violence prosecutions, or cases where there's a DNA hit from an old rape kit and we get a CODIS hit, we might have another victim that we discovered the defendant is victimized in a similar pattern or similar way, or using similar methods as the current victim. That can provide evidence that can be offered under 404B. Sometimes in intimate partner violence, in intimate partner cases and investigations, some of the abuse and the cycle of violence, it doesn't even come through the criminal system. Law enforcement's never contacted, but there can be civil protection orders. By exploring the docket and going through the docket, we can find incidents that gave rise to these orders, maybe incidents or times when these orders were violated. And we can try to incorporate that into this current prosecution as 404B evidence. There might also be old police reports that can reveal 404B evidence. And I'm speaking of police reports, not just those which identify the current offender as an offender in the past, but sometimes there could be incidents where the offender maliciously called police on the victim on prior occasions. There could have been neighbors responding to noise complaints at the residence and things of that nature. By looking for police reports a little bit more wider than the offender as a past offender and the victim as a past victim, but looking at the actual address or location and prior addresses and locations, we can usually find a wealth of evidence. The other thing, if the opportunity presents itself, or if we ask, if our offender has prior partners, usually intimate partner violence and non-stranger sexual violence, it's not an isolated incident. These are usually serial offenders. If we have ability, usually maybe through our victims, to identify some of our defendants' prior partners, approaching those prior partners in a sensitive and compassionate way and asking them about their history with the offender may allow us to be able to utilize evidence under 404B. In addition, especially in this day and age in 2017, looking at a defendant's social media and jail calls, that can be certainly a labor-intensive effort at a minimum to try and find bad acts evidence, but it can pay off. We look through social media, we get to see the things the defendants are saying, jail calls. We can find efforts to intimidate or induce our victims and witnesses not to participate in a prosecution. Not only can that lead to additional charges, but it can also help us show intent and evidence such as that under Rule 404B. And finally, when we're speaking to third-party witnesses as well as our victim, oftentimes we see offenders, and we've seen it at trials where defendants offer reputation evidence as to the reputation for nonviolence or being law-abiding. One of the things we want to do that can also help us learn about a defendant's prior history and perhaps uncover 404B evidence is that when we're investigating the case, when we're speaking to the victim's family and friends, the offender's family and friends, ask about the reputation. And we want to have our investigators ask about the reputation. And we may find specific incidents that can be utilized in this prosecution. However, all of this, of course, takes preparation. And the important thing to remember, we talked about the initial slide where we just have a charged incident, and that's how we look at it. But when we're looking at these cases in context, when we're going more to that aerial view to try and get the overall story or picture of the context of this offender's criminality, it requires effort and it takes time. It takes time to talk to these people. It takes time to talk to the victim and learn about an entire history, especially if it's been an involved relationship. It's an investment of effort by the prosecutor and, of course, by the investigator. Well, let's talk about now about the proper purposes for which evidence can be offered under Rule 404B and try to give some specific examples of each. By no means will these examples be exhaustive, and the proper purposes of motive, opportunity, intent, prior preparation, knowledge, identity, lack of accident, and mistake. When you're looking at the evidence in your case, try to think how the evidence of the defendant's other acts, prior bad acts, how it can be applied to each of these purposes. And what we want to do right now is just offer some examples of how they can sometimes be used. What type of evidence can be admissible to prove motive? Well, of course, in regards to motive, we never have to show why a defendant committed a crime, only whether a crime was committed by the defendant. We only have to show the what, not the why. Regardless of that truism, motive can be helpful in proving the crime. And I'd suggest that in the context of using 404B for intimate partner violence prosecutions and sexual violence prosecutions, motive and intent are probably going to be some of the most common purposes about which we'll try to, for which the defendant's bad acts will attempt to be offered. Examples of bad acts of the defendant that can be used to show his motive in the current crime is if the defendant had made prior threats of violence, whether that be verbally or by electronic communication, social media, text messages, what have you. That can be, we can seek to introduce evidence of those threats in the current prosecution to show the motive for their current crime. If there's a text the defendant gave to the victim, if you go out again without asking or without telling me, I'm going to kick the bleep out of you, that threat is not only an individual bad act, but it also shows the defendant's motive when the offender assaulted our victim. If there's evidence of victim participating in prior prosecutions or investigations and the defendant retaliating against that, that might be offered to show the defendant's motive for the current crime. In other words, anger, resentment, or just a tool of control over the victim because in the past that victim has cooperated with investigators and prosecution. And often and sometimes motive is also a way to, or for purposes of motive, if our defendant was set off in the current case by jealousy or possessiveness of the victim, then looking through the past history of the relationship can probably reveal other incidents motivated by that. And often by trying to sort of proactively take that evidence and utilize against the defendant, it can often blunt efforts by the defendant to try and attack the victim's credibility, to suggest that the victim is making this up because they wanted to start a relationship with the other person. By exploring history, often we find out that the defendant viewed the victim as someone to control and possess, and we look for those other incidents and we can find motivation in the current case and take something that our offender might have used against the victim and make it offender focused as to why they committed the crime and why our offender brought our victim and everyone else to court. What type of evidence, let me go to the next slide, what type of evidence can be admissible to prove opportunity? What we want to show with opportunity evidence under 404B is that the defendant had the means to commit the crime. In other words, that the defendant created circumstance that facilitated the crime. Sometimes the opportunity purpose under 404B, it can be thought of as means evidence. A good example, or some examples that would apply to this, is if there's a dispute or if there's a question, an evidentiary question in the current case as to whether the defendant possessed a weapon that was used to threaten or utilized against our victim in the current case. By finding past incidents of witnesses or individuals who saw the defendant with the weapon, we can offer that under an opportunity purpose of 404B. Certainly if the defendant had utilized that weapon to make prior threats, that can be probative of the defendant utilizing the weapon in the current case. You could even argue, and you could argue to the trial court, if the defendant has used similar weapons to make threats in the past as he is in this current case, it could also help show the defendant's, it could be evidence of the defendant's opportunity to do it in the current case if that's not conceded by the defense or denied by the defense. What type of evidence may be admissible to prove intent? Now, as I suggested before, probably the most common purposes which we are going to be utilizing as prosecutors to try and get evidence admitted under 404B will be to show motive or to show intent, to show that whatever act the defendant is accused of committing was intentional and why the defendant wanted to do it. Prior assaults or previous assaults against the current victim or against different victims can help show the defendant's intention in the current crime. Now, often, as most everyone knows, when you're a prosecutor, it's very rare where we get the case where the defendant is courteous enough to specifically state what their intention is in terms of whatever our statute requires. In terms of an intentional murder case, sometimes we do have a defendant, but it sometimes can be uncommon for the defendant saying, I specifically intend to kill you. Or in terms of assault statute, we don't often have defendants specifically stating, I intend to cause you serious injury, bodily injury, or whatever the element is. More often than not is that intent can only be proven with circumstantial evidence of a defendant's state of mind. Prior bad acts of the defendant or the other previous bad acts of the defendant showing their intent in the current case is one of the best vehicles to do that. So in other words, if we have an incident or current incident where our defendant has assaulted the victim, they've utilized the weapon, they've beaten them badly, they've caused injury, and the defendant wants to say that well, it was self-defense, I was just defending myself, or it was a mutual combat type scenario, and if that's what the defense is framing, or trying to suggest, even just suggest to the jury to raise reasonable doubt. Going through this history, finding the defendant's previous threats to the victim, the defendant previously exercising control over how the victim can live their life, helps to undermine that and helps to show that the defendant's intention in this case, it's not what they're suggested, but it was an intentional act. Especially if we have a general intent crime based on not a specific intent, but maybe a mental state or mens rea of malice, then the prior bad acts that a defendant did can help open that door to show that sort of wickedness of disposition or hardness of heart in this current case. We show how the defendant has previously acted to the victim to show that what their intention was specifically. As I alluded to, if a defendant committed the current crime in a similar manner with prior victims, that may also show their intent in perpetrating the crime with the current victim. This is especially useful in the context of alcohol-facilitated assaults. If our current victim in the case, it's an alcohol-facilitated sexual assault, and the defense is just saying it was some sort of, or trying to assert or frame the case in terms of a mutual sort of drunken sexual encounter, then finding prior victims of the defendant where they prey on victims who are being made vulnerable by intoxication can help show the misdirection and the untruth of that type of defense. Prior bad acts showing intent is often going to overlap with other types of purposes for which evidence can be admissible under Rule 4 or 4B, such as motive, preparation, and things of that nature. What type of evidence can we offer that may be admissible to prove preparation, plan, or knowledge? Well, evidence of steps taken to accomplish the crime, such as isolating the victim, having stalking behavior of the victim, whether it's the sort of stereotypical concept of stalking, such as following the victim about, or the more legal context of stalking, such as engaging in the course of conduct designed to put the victim in fear of injury or emotional disturbance, or instilling vulnerabilities, that can help show those actions can help show the defendant's preparation, plan, or knowledge in the current crime. In a human trafficking context, if a trafficker is sexually assaulting the victim, then that could be offered as evidence of plan to isolate and intimidate a victim for human trafficking. If you have a sexual violence case with intimate partners, and that relationship also includes physical violence, the history of the physical violence perpetrated by the defendant on the victim can show in the sexual violence case their effort to forcibly compulse the victim in the current prosecution. In other words, if a victim if an intimate partner is being sexually assaulted by the offender, if there's a history of violence, that can help put the current crime of sexual violence and the defendant's utilization of forcible compulsion into context. And again, prior crimes that an offender perpetrates against other victims in a similar way can also be offered to help show their preparation, plan, or knowledge in the current case. Another proper purpose for 404B is to show, to prove the identity of an offender. When identity is at issue, evidence of specific modus operandi or signature crimes can be introduced to prove identity. Signature means behavior prior to, during, and after the criminal act. And the sort of illustration of this is for folks of the old serials shows when Zorro left the Z after he attacked. That was considered an example of a modus operandi, but of course one that can be copied. This purpose under 404B, it's less useful if the defendant's identity is not at issue. And often in cases of intimate partner violence and non-stranger sexual violence, the identity of a defendant is not often going to be an issue. And so this purpose under 404B is not probably going to be one of the more commonly utilized purposes that we're going to be looking for in intimate partner violence prosecutions and sexual violence prosecutions. Type of evidence that we can be admissible to prove lack of accident or mistake. This can work similarly to evidence that we used, bad act evidence we used to show evidence of intent. But what this can show is that the defendant was aware of the nature of the acts when committing the current crime. Claims or argument by the defendant that the current case was a misunderstanding or accident are less believable when the defendant is a serial offender. This purpose under 404B, it lends itself, when properly and thoroughly investigated, to prosecutions of serial offenders who of alcohol-facilitated sexual assault. It can also be helpful in showing the lack of proof or credibility in any defense claims offered by the defense when we find a history of prior assaults. Now, 404B, it's not exhaustive. Again, it's a rule of inclusion. 404A is a rule of exclusion. 404B is a rule of inclusion. And the specific stated purposes we just discussed, that's what's in the rule, and hopefully we've had an opportunity to give some examples about how that can be utilized. But there can be other purposes for which evidence can be offered under 404B. If it's relevant and probative, where the prior bad act can help show the defendant's state of mind in the current prosecution, that should be something that should be explored. If there's evidence which the defendant opens the door to, and the defendant's bad acts become relevant to impeachment or rebuttal purposes, that's be useful. If a defendant makes a statement or a on the stand, I've never committed a crime or I never hurt anyone, that can certainly broaden the admissibility of the defendant's prior bad acts. If the prior bad acts can help show the defendant's consciousness of guilt in the current case, that can be another window. I remember at one point I had a homicide prosecution where the offender had just shot his spouse 2 or 3 times, and police responded, an emergency response team responded, and the defendant had barricaded himself in the basement, and he shot at one of the responding officers. And of course, what we argued that the shooting of that police officer was consciousness of guilt for just having murdered his wife. Certainly other purposes of which a defendant's prior bad acts can sometimes be admitted is if it's an element of the charge. And this is why stalking charges, when there's an opportunity to charge stalking and the investigation reveals evidence of stalking, that's something we want to utilize. Because the litigation contests we've described in this case about trying to get 404B evidence in by arguing whether or not it's probative versus prejudicial value and part of a proper balancing test, that becomes tremendously easier if the evidence or conduct which we're trying to get in is we can get it admitted as part of a course of conduct for a stalking charge, or the prior bad acts is itself a charge, an independent charge in our prosecution. Another purpose a defendant's prior bad acts may come in is if we're trying to prove a prior existing relationship. Maybe there's co-conspirators or co-defendants in our intimate partner violence prosecutions or sexual violence prosecutions where that can be relevant and open the window. So ultimately, what we want to talk about and what we've referenced throughout this is that 404B, an evidence offered under 404B, it's a rule of inclusion. And we should approach the rule and evidence we're seeking to admit under that, not apologetically, but proactively and proudly. It's something that's permitted and allows us to give the whole story to the jury. It permits admission of evidence for purposes other than just showing the propensity of an offender, because we don't care about evidence that just shows a propensity because that's not what's admissible. But we want to offer evidence, the defendant's prior bad act evidence, in a manner that helps prove our current crime for one of the proper purposes that we've already articulated, while of course recognizing that that list of purposes is not exhaustive. Now, of course, the defense will be offering challenges, and it'll be the rare circumstance when our defense bar friends just concede the evidence we're trying to seek against the 404B. And the efforts of the defense bar to usually contest this evidence, I think, is a good illustration of how valuable and how helpful it is for helping the fact finder get to a result that reflects the truth of what happened in a criminal activity. And let me just address it, and again, this is by no means exhaustive, but sort of talk about some of the typical defense arguments against the admission of 404B evidence that can come up. Sometimes what an argument that can be commonly heard is that the evidence which we're trying to admit, it's different conduct than that which is charged. And this, of course, applies when we can't use the prior conduct to bring in new charges of stalking or other crimes. That is, of course true, but what we always want to stress, and hopefully the evidence we're offering to the court, is while it's different conduct than the crime charge, we want to bring it back to the case that we are currently prosecuting and how it's necessary for us to meet our burden and prove our case in the current prosecution for whatever purpose or purposes we are offering it under. The defense will also argue that there's different circumstances in the prior case. And of course, whenever we have two incidents, you can always find things that are different, and you can always find things that are similar. I think the things, depending, we want to do our research in our local jurisdiction, and Equitass can, of course, assist with that. But we want to help our courts to understand is that the crimes don't have to be identical, but they just have to help illustrate the purpose for which they're being offered. Again, 404B is a rule of inclusion, not of exclusion. The defense may argue that it's too remote in time. Then if it is too remote in time, that can be a good argument, unless we can show that the probative value is so incredibly high that it counterweighs or is more significant or more weight should be putting on than remoteness in time. Certainly with a lot of sexual violence cases, especially child sexual assault cases, the nature of the crime being committed is a good way to rebut arguments against the 404B evidence coming in as being too remote in time. It's not offered for one of the specifically named purposes. Well, hopefully that's not a defense argument we're often going to be hearing, because we have such carefully crafted and limiting motions prior to our efforts to try and argue its admissibility. It's another defense argument is that the 404B evidence is offered to prove an issue that is not seriously in dispute. Probably one of the best responses we can make to that is, well, it's ultimately up to the discretion of the trial court to weigh what is or isn't in dispute. Often the jury gets to decide these issues, and what they think is in dispute may not coincide with what the prosecution or defense thinks is in dispute. So while appreciating the defense concession about an issue that's not seriously in dispute, a good rebuttal to that defense argument is that ultimately we can't anticipate what the jury of 12 is going to do. And sort of the default argument you often hear in contests about whether 404B evidence should be admissible is that it's more prejudicial than probative. And of course, just the response to that is to stress, but it's not unfairly prejudicial. So going forward, what we want to do is we want to utilize, we want to provide context in our domestic and sexual violence cases. We want to effectively litigate 404B motions pre-trial to ensure appropriate evidence is admitted in court, and make sure that we have that good solid record for any appeal when we hopefully get our conviction. And we want to use prior bad act evidence to recreate the reality of the crime and connect with the jury. So my name is, and you have my card here, identification. My name is Jonathan Curlin. You have my contact number. The phone number is my direct number. And again, anytime myself or any of my colleagues at Equitass can use to assist your prosecutions, investigations, whether you're a prosecutor or similar allied official, please contact us, and we want to do what we can to help. Thank you so much for your time and your participation in this webinar.
Thank you, John, and again, thank you everyone for coming out and viewing this. We have recorded it, so I will be sending out that link. So if you want to share with a colleague or refer back to something that Jonathan was talking about, you'll have that. And I will be sending out his full biography as well as the slides again, just with the updated grant information. But thank you again for your attention. And like John said, Equitass is 24/7 technical assistance provider. We're available to help you out in any way that we can. So thanks again, and we'll talk to you again soon.